So you sent us a copy of the voice recording, I think, was that yesterday?
Oh, it may have. Yes.
Yeah,
Uh,
because I got a copy of it and I was like, I didn't listen, but I knew that's what it was. I was like, oh, okay.
yeah, Teams will do an auto recording and transcript so that folks can read or view it at a later time.
Yeah.
All right, it is 2 o'clock. I'm gonna give folks about 30 more seconds to log in and then we'll get started. If you're one of my presenters here, if you wouldn't mind muting yourself while we go through kind of the beginning portion of housekeeping notes. We have a lot of folks jumping in right now, so give them a couple more seconds. So I first want to say thank you to everyone for joining today's virtual panel on fair housing presented by the Indiana Civil Rights Commission. As you may know, April is Fair Housing Month as it marks the anniversary of the Fair Housing Act being signed. We're really excited to dig into today's topics. My name is Anne-Therese Ryan, or everyone calls me AT, and I'm the Public Outreach and Education Manager for the Indiana Civil Rights Commission. I'm also honored to serve as today's moderator for the panel. Before we begin, I want to mention a few housekeeping things. We want to mention first that this webinar is being recorded, and the recording will be made available on our website and YouTube tomorrow. To access captioning for this webinar, you will want to click on the button titled More in the toolbar. In the drop-down menu, select Settings, and then a second menu will pop out and you will click Accessibility. On the side panel, toggle the slide to turn on captions. These instructions will be dropped into the chat. If you experience any technical difficulties during the webinar, we recommend that you try leaving the webinar and rejoining. If you continue to experience technical challenges, my colleague Brooklyn will try to help you troubleshoot in the chat. Please also note that the recording will be made available and you can view that at your own availability. We'd like to remind everyone also that we have another panel. We'll be hosting this panel on Monday, April 24th at 2 p.m. And our team is now dropping the registration link to that panel for those who have not already registered. There's also a QR code on the screen. So if you would like to scan that now with your phone, you can be taken directly to the registration page. We hope we will see everyone who's here today at that panel as well. Today's webinar will begin with presentations from each of our panelists, and then we'll conclude with a questions and answers session. If you have questions throughout the panel, please click the chat button on the toolbar and type in your question. We will have time reserved at the end, if time allows, to address audience submitted questions. Let's go ahead and get started by introducing our panelists for today. We will hear from Melissa Deering from the Indiana Civil Rights Commission, Darlene Sweeney Newbern from the Ohio Civil Rights Commission, and Stephen Monroy and Oral Bennett from the Illinois Department of Human Rights. We're excited to have all of our regional partners here to be able to share their unique perspectives on fair housing. Today's webinar will begin with a presentation from Melissa Deering. Melissa is a program director here at the Indiana Civil Rights Commission. She supervises the REPACE unit, which oversees all investigations of discrimination complaints in real estate, public accommodation, credit, and education. Prior to coming to the commission, Melissa was a grant manager at the Indiana Criminal Justice Institute, where she managed a multi-million-dollar grant program. She has a BS degree from the University of Indianapolis and over 16 years of investigative experience. Melissa has worked in state government for over 30 years. Thank you so much, Melissa, and you can take it away.
All right, thank you, AT, for that wonderful introduction. As AT mentioned, my name is Melissa Deering. Well, first, let me say good afternoon to everyone, and thank you for attending this Fair Housing panel, and thank you for joining us today. Again, my name is Melissa Deering, and I am the Program Director for the Repace Unit at the Indiana Civil Rights Commission. I'm going to share my screen. I'm going to try to share my screen. Okay, let me bring it back up here. These are those technical difficulties we were talking about earlier. Okay. Okay, can you all see the presentation now?
Not yet, Melissa. I think Brooklyn's coming by to help you.
Okay, can you see it now? Not yet?
No, not yet.
Not yet,
We can see
okay.
your Genesis cloud.
Okay. Hold on one second. I think I have to unlock the door.
I'm here to save the day. Are you muted?
Yeah. No, it's not.
Laptop's like frozen.
I know. All right. I have to leave and come back.
Your Teams is like frozen.
We can do a little improvising. And if Darlene, if you're ready, we can go to yours and come back to you, Melissa.
Okay.
So,
I sure am.
awesome. Yeah, we we shouldn't have mentioned any technical difficulties beforehand. So
Told you.
our first presentation will actually be from Miss Darlene Sweeney Newburn. Miss Sweeney Newburn currently serves as the I'm going to spotlight her for everyone. Currently serves as the Director for Regional Operations for the Ohio Civil Rights Commission. She has over 33 years of experience in investigating, supervising, and managing employment and fair housing charges for the commission. She's traveled throughout the United States, speaking, teaching, and training individuals on fair housing laws and employment laws. Ms. Sweeney Newburn has been an instructor on fair housing laws and the author of 2 fair housing training manuals. She's a popular motivational speaker who has presented at national and international conferences. We're excited for her to join us today. The floor is yours, Ms. Sweeney Newburn.
Well, thank you. Hello, everyone. I am from the Ohio Civil Rights Commission. Similar to, as I call them, ICRC, the Ohio Civil Rights Commission is the leading agency that investigate the anti-discrimination laws. Basically, for us, it's Ohio Revised Code 4112. And in this capacity, when one alleged that they were discriminated against in the areas of housing, employment, places of public accommodation, credit, and higher education on the basis of disability, that's when Ohio Civil Rights Commission will investigate if you allege that it was based on your race, color, religion, sex, national origin, ancestry, disability, age. And in Ohio, we also have military status. So this is the Ohio Civil Rights Commission. As with many of you right now, we are a law enforcement agency. We are not a courtesy or advocacy group. As such, and because we're time limited, let's talk about what I wish to talk about today, which is discriminatory appraisals. Where we live, where we work, and where we play is so important to all of us. It is just the essence of what it is that we do, particularly as adults. And when you grow up and you're on your own and you have your own family and you have your children, those things are so important to you. But just imagine that you have, or you believe you realize the dream and you have this beautiful home, and all of a sudden you want to do a couple things. You want to refinance your home, or maybe you want to sell your home. Now, you purposely chose this home. You basically know how much this home is valuated. You have an ideal. Most people, now there are some people who are way out there, but for the most part, you basically know what this home should come back as a valuation. And because you believe in diversity, you, for the most part, either live in a diverse neighborhood, or perhaps you chose a neighborhood that was really, because your neighborhood matters. But I'm going to tell you, when you talk about discriminatory appraisals, it's going to happen one or two ways. Either it's going to be intent, that they intentionally, if you stay in a predominantly white neighborhood, devalue your home, or it's going to be systemic because you are in a predominantly African American or Latino neighborhood. All the homes that way will be devalued. So what are we talking about here when we talk about this discriminatory appraisal? We're actually talking about undervaluing your home because of your race or ethnicity, religion, or other protected classes. I've seen it more when it has to do with race or racial composition of the neighborhood. What is going on here, which from a historic perspective, they've always done this. It's kind of strange here, because by way of history, ever since they introduced appraising of home, they have appraised differently based on race or racial composition of neighborhood. Then you fast forward to the days when predatory lending was at its high. And then back in the early 2000s, late 99s, early 2000s, they over appraise your home. For example, your home could be falling down and it's only worth 20, 30,000. Heck, I've even seen it where houses were condemned. They will appraise your home and said, nope, that home is worth $100,000. So you were in trouble that way as well. Then you fast forward, you start getting to later to past 2010, 2015, and you started really conquering this discriminatory appraisal where they were over evaluated. So it's under evaluated, over evaluated. Now we've come full circle where they are devaluing the homes. There are so many studies out there. I can tell you that Freddie Mac, the quasi government agency, that's the big wheel that have to do with all the mortgages. Freddie Mac, they did a study and they took it from like 2015 to 2020, and they said they did 12 million appraisal, and that these appraisals showed that still as of 2021, but we know it's now as of 2023 as well, that racial disparity exists. You're going to find these disparities mostly in the Latino and Black areas where they are appraised, and there's a few studies out there that I know of, and they all say the same thing, that they are appraised 20% less than those in terms of value of those that's in white neighborhoods. I can tell you in Ohio, there's Erica Parker and her husband, Aaron, and they knew what their home was worth. And so they came in, they got an appraisal done on their home because they wanted to sell this home. And the appraisal came back at something like $457,000. They knew there's no way that home, they had expected at least 500,000 or more. So what they did, and this is a term that if you haven't heard it before, I will introduce it, called whitewashing. You can visit YouTube, you can visit different of the major stations, and you're going to see story after stories and interview after interviews of individual who whitewash that house. And what that means is you take away everything that has to do with your family. Now imagine having to do that. Take away your family pictures, anything that would identify you as a minority, anything that would speak to the fact that you are Black or African American or Latino. You get all of that out the house, including yourself, and you find a white friend, a white relative, a white whoever. They're the ones who will meet the appraiser, and it'd appear as if it's their house. When the Parkers actually did this, their house came back about $100,000 higher than before. But I've heard the stories where they've come back as much as $400,000 to $500,000 more when you whitewash your house. So the trend is for African Americans and Blacks to whitewash their homes, to get a better appraised value. So, okay, Darlene, your property was under appraised. So, what does all of this mean? Because really, what the market bears and what people want, they'll pay for that house. Your house may appraise at 200,000, but if somebody wants that house, they still may pay 250,000. You do have a couple problems with this, because again, that house then may put you underwater pretty quickly. Something may happen and you might need to sell. What if there's a fire and they're saying, hey, you have a market value policy and this is all you're going to get? So it does pose problem, but the biggest thing here has to do with wealth and generational wealth. And we know there's a huge gap between the wealth of based on the different races, whereas African Americans and Latino basically on the bottom. So when you undervaluate these homes, you are in fact taking away wealth in this particular family. In fact, it's estimated that the cost of this devaluation of homes in particular neighborhoods is somewhere around 162 billion. I know that this is so important to HUD. HUD takes on different projects. I know the lending, the discriminatory appraisal is one thing that they're looking at. And I believe HUD even put together a task force to study and to address this. Because we're time limited and I'm really at the end of my time, all I have to say is that discriminatory appraisal is just part of the story. I want to raise your level of consciousness to this, because the lenders They're not mutually exclusive from the individuals or the appraisers that's doing this. So all of this actually works together to put together this whole model of denying or devaluating based on race or racial composition of the neighborhood. You have to throw in also the insurance industry, who will possibly not give you a replacement cost policy, but a market value policy. So, in conclusion, just know that when it comes to discriminatory appraisal, it is on the rise. And I would like to raise your level of consciousness to be on the lookout, because as law enforcement agencies, you have the ability to address. Thanks, everyone.
Thank you so much, Ms. Sweeney Newburn. I really enjoyed hearing that presentation. I hope everyone else did as well. We are going to, if all of the technical issues are resolved, I think we're going to go back and give Melissa another shot, and then we'll end with our folks from the Illinois Department of Human Rights. So just so everyone knows, we just heard from Darlene Sweeney Newburn, and we're going to be going back to hearing about hearing from Melissa Deering of the Indiana Civil Rights Commission. So Melissa, you have the floor.
Thank you very much, AT. Good afternoon, everyone. Again, I apologize for the technical difficulties. We are going to go ahead and get started here. Again, my name is Melissa Deering, and I'm the program director for the REPACE unit at the Indiana Civil Rights Commission. Today, I'm going to be discussing director-initiated complaints, and specifically what gives the commission the authority to investigate those complaints. I'm also going to be talking about a couple partnerships we have to eradicate discrimination through testing. And then I'll also be discussing some types of director-initiated complaints which we may receive in our office for investigation. The Indiana Civil Rights Commission enforces the Indiana Civil Rights laws, Indiana Code 22-9, and the Indiana Fair Housing Act, Indiana Code 22-9.5. The agency does serve the entire state of Indiana, except where there is a local civil rights organization within that city or local. The Indiana Civil Rights Commission's jurisdiction extends to individuals, private or public entities, housing providers, and business establishments within the state of Indiana. The Indiana Civil Rights Commission's mission is to neutrally investigate complaints with the mission of or goal of eliminating discrimination against protected individuals in the enforcement areas designated by the Indiana law. The purpose of the Indiana Fair Housing Act are to provide for fair housing practices in Indiana, to create a procedure for investigating and settling complaints of discriminatory housing practices, and to provide rights and remedies substantially equivalent to those generated under the federal fair housing law. The enforcement areas that are covered by the Indiana Civil Rights Commission are housing or real estate, employment, public accommodation, credit, and education. Discrimination in those enforcement areas prohibit certain characteristics, or sometimes called protected bases. Those bases include race, religion, color, sex, disability, national origin, ancestry, and familial status. There is an additional one, veteran status, which is only covered in employment and public accommodation. We all know that race, religion, color, sex, disability, national origin, and familial status are the bases that are specifically covered under the Fair Housing Law. An aggrieved party who has the ability to file a complaint is anyone who can show that they have been injured by a discriminatory practice. Now, an example of that could be someone who is employed at an apartment complex or by a landlord, and they question some sort of discriminatory practice or policy that that landlord has, and then that person or individual is terminated. This is kind of an unusual case that is can be taken under the Fair Housing Act based on that employee getting retaliated against because they opposed a Fair Housing Act discriminatory practice. The Indiana Code extends this right to include executive director initiated complaints as well. Sellers, landlords, leasing agencies or agents, realtors, homeowners associations, mortgage providers, etc., are all subjected to the fair housing laws. So they have to abide by the Fair Housing Act as well. As previously mentioned, the Indiana Civil Rights Commission has the authority to create director-initiated complaints. When this occurs, the director becomes the actual complainant for purposes of furthering the commission's mission and eradicating discrimination. What gives the Indiana Civil Rights Commission the legal authority to investigate and create a director-initiated complaint? The agency basically relies on the IC 22-9 and the Fair Housing Act IC 22-9.5. And you can see here the specific codes that allow us to investigate those specific complaints and draft them. Okay. All right, the Indiana Civil Rights Law states, it is the public policy of the state to provide all of its citizens equal opportunity for the acquisition through purchase or rental of real property, including but not limited to housing, and to eliminate segregation or separation based solely on protected classes. Complainant means the director of the commission charging that a discriminatory practice was committed against a person or a class of people in order to vindicate the public policy of the state. The commission may conduct such investigation in the absence of complaints whenever it deems it in the public interest. So this kind of sums up that authority that we are given under the civil rights law to investigate and draft those director-initiated complaints. The Indiana Fair Housing Act states, upon the written direction of the Indiana Civil Rights Commission's executive director, the agency may initiate an investigation of housing practices where the director determines that the alleged discriminatory practice contained in the complaint are pervasive or institutional in nature. Later, I'll talk about our process and how we investigate those complaints that we get in through our director-initiated complaint process. Processing the complaint will involve complex issues or novel questions of fact or law, or affect a large number of persons. The Fair Housing Law also specifically states that providing inaccurate information to testers is a form of impermissible discrimination. A director-initiated complaint can be derived from either testing, as I mentioned before, or either discriminatory policies or discriminatory advertisements. We normally investigate tester cases under the disparate treatment theory, which means a protected tester was treated differently than a controlled tester. When we're investigating director-initiated complaints involving discriminatory policies or advertisements, we're looking at the disparate impact theory, which means a rental criteria policy has an adverse impact on a certain protected group, or the advertisement shows a preference for tenants who are not of the protected group. While the majority of our commission's housing complaints are investigated based on an individual filing a complaint, we currently do have partnerships with the Indiana Housing and Community Development Agency and the National Community Reinvestment Coalition to conduct testing of properties to determine whether further investigation is necessary through a director-initiated complaints. And we will continue to work towards eradicating fair housing discrimination. Thank you for attending, and I hope I was able to provide you all with some useful information.
Thank you so much, Melissa. Our next presentation is from Stephen Monroy and Oral Bennett from the Illinois Department of Human Rights. Stephen Monroy is the Director of Fair Housing at the IDHR and oversees fair housing investigations statewide. Stephen also manages IDHR's partnership with the U.S. Department of Housing and Urban Development and advises IDHR senior leaders on fair housing policy. Stephen holds a Juris Doctor degree and bachelor's degree in political science and criminal justice from Loyola University, Chicago, and Stephen is a veteran of the Illinois Army National Guard. Oral Bennett is the chief litigation attorney and housing at the Illinois Department of Human Rights. In his role, he supervises staff attorneys who review discrimination cases for substantial evidence, responds to requests for review, and litigates housing discrimination cases at the IDHR. Originally from Jamaica, but calling Naperville home, Oral earned his bachelor's degree in political science from the University of Nevada in Las Vegas and his Juris Doctor degree from Creighton University in Omaha, Nebraska. Thank you both for joining us today, and the floor is yours.
Thank you, AT. Good afternoon, everyone. First, I'd like to thank the Indiana Civil Rights Commission for inviting Stephen and me to present at today's conference on the state of Illinois' anti-discrimination law, the Illinois Human Rights Act. My name is Oral Bennett, as previously stated, and I'm the Chief Litigation Attorney for Housing with the Illinois Department of Human Rights. I'm joined by my colleague, Stephen Monroy. He's the department's Director of Fair Housing. As previously noted, I won't get into the many things that Stephen is in charge of doing, but it's quite a bit. So thank you, Stephen. So similar to Indiana and Ohio, the department has jurisdiction over 5 areas: employment, real estate transactions, financial credit, public accommodations, and sexual harassment and education. Today, Stephen and I will be focusing on the area of real estate transactions, and more specifically, arrest records and source of income in the housing context. Stephen's work primarily focuses on investigations of charges alleging discrimination, and my work focuses on adjudicating cases after a finding of substantial evidence. My presentation will cover arrest records, and Stephen's will cover source of income. So under the Illinois Human Rights Act, landlords, housing providers, and any other person engaging in a real estate transaction are prohibited from using a person's arrest record when engaging in a real estate transaction. The Act defines an arrest record as an arrest not leading to a conviction, a juvenile record, a criminal history record ordered, expunged, sealed, or impounded under the Criminal Identification Code. Typically, the use of an arrest record will appear or show up when someone attempts to rent, lease, or purchase real estate. So now that you know what an arrest record is, what are some of the prohibited uses of an arrest record. Generally, under the Act, a landlord, housing provider, realtors, etc., they may not refuse to engage in a real estate transaction with someone who has an arrest record. They may not. So typically, that situation would be a person with an arrest record attempts to rent an apartment, purchase a home, and the seller, landlord, they're aware of the person's arrest record and refuses to engage in the transaction because of the arrest record. Also, they may not subject a person to discriminatory terms and conditions because they have arrest group, where if a tenant at one of the landlord's units gets arrested and is subsequently, in their home, and they request some form of repair to their unit, the landlord is familiar with their arrest and decides, not to make the repair because the person has been arrested. So comes up in that scenario. They may not also refuse to convey an offer to rent or purchase because the person has an arrest record. That's self-explanatory. Refuse to negotiate, similar to refuse to convey an offer. Make a discriminatory statement which expresses a preference or limitation based on the person's arrest record. So, the landlord, housing provider, or the person engaging in the real estate transaction cannot make a statement that, I will never rent to anyone who has an arrest record, or, I'll never rent to. Essentially, if it comes up, it would be something like that. They may try to use words that are implicit to that, and that would be chargeable as well. And the last thing is, in listing properties, real property, the housing provider, landlord, seller, what have you, they cannot list the property with an intent to exclude based on the person's arrest record. So, once a person has been subjected to one of these areas, what can they do about it? Well, they can file a charge with the Department of Human Rights. There's two different ways to prove that they've been discriminated against. Number one is they can file a charge essentially alleging a disparate treatment, and that would be an individual cause of action. In that case, they would just have to prove that they have an arrest record. They attempted to rent an apartment. They were denied, and the denial was based on their arrest record. And then disparate impact, they can also bring a case based on disparate impact. Disparate impact is basically the landlord or housing provider has a policy that has a disparate impact on people who have arrest records. So they can bring a claim under that theory of discrimination, and the department would conduct an investigation accordingly. And the Illinois Human Rights Act has an exemption for landlords, housing providers, anyone engaging in a real estate transaction who are allowed by state or federal law to use or inquire about a person's arrest record. So that's a defense that they can use, that state or federal law allows me to inquire or use an arrest record to deny someone property. That's my portion of the presentation. I'll pass the baton to Stephen. He will cover source of income discrimination.
Yes, thank you, Oral, and pleasure to be here, everyone. Stephen Monroy, Director of Fair Housing from the Department of Human Rights for the state of Illinois. Thank you so much to our colleagues from Indiana for having us here today and giving us the opportunity to share, these recent protections that were added to the Illinois Human Rights Act. as Oral was mentioning, our arrest record protection. That one is relatively new. I believe it was effective in 2020, and the even more recent law that I will speak about, which is source of income discrimination, that one is effective just this year. So for both of these protections, we've been really excited to be speaking to the public about them and seeing as how these cases develop, because these are very relatively new protections, especially when compared to the protections that overlap with the Federal Fair Housing Act that have been tested for over 50 years. So the source of income protection in Illinois is similar to source of income that has been passed across the country. So various states, local jurisdictions, including cities and counties, have made the policy decision of saying that we're going to make sure that individuals' source of income is protected, because it's not only just their disability, their race, other demographics that could exclude people from certain areas. It could also involve source of income. So the fact that somebody doesn't have that relies on something other than employment income, so something like disability income or Section 8 vouchers, that does have a real impact where people live. So in terms of Illinois, our protection, of course, as in every other state, is very specific to how the term was defined in the Illinois law. In our case, it means the lawful manner by which an individual supports himself or herself and his or her dependents. So it is a very broad law. So other states that have source of income protections might be different. But in Illinois, it is very broad, and the key is lawful, and it's the manner in which they support themselves. Some examples of this that are things that we're likely to see coming in our cases and that we're hearing questions about from the public. These include, of course, employment, income from employment, which is traditionally accepted and recognized, the most common one. So very clearly that is still protected in Illinois, and it should be treated the same as other sources of income. So some of these alternative sources that we're seeing, and was the impetus of the law, were things like disability benefits, emergency rental assistance, especially during the height of the COVID pandemic, where many individuals were at risk of being evicted. There was funding that covered their rent and their ability to keep up with their payments. So things like that was emergency assistance, but also traditional longer term forms of assistance, such as Section 8 vouchers, aka housing choice vouchers. And then other things that are very common, but sometimes aren't thought about, such as maintenance and child support or Social Security benefits. There is been a long time industry practice of asking individuals for their W-2s or their pay stubs and the ability to prove to prove their ability to keep up with the rent. And source of income basically furthers that policy of saying, if a landlord is accepting or certain forms of income, they should be able to reasonably accept other ones as well. And if they're requiring documentation for proof of it through those pay stubs or income, they must also accept other proof. So the key is that the source of income is verifiable and their practices. So some examples of what source of income discrimination look like, which is very similar to what Oral was discussing in arrest record. It is key to some kind of harmful action, some kind of negative action against the person, whether they're applying for new housing or they're applying to renew their housing. It could also pertain if somebody is applying for a housing related transaction, so applying for a loan, some other thing that's key to that process. So very common examples that we've seen and heard about in the community that we're expecting to be part of some charges are preferencing specific individuals, of saying we want to have just people who have employment income, and then we're not going to accept individuals that rely on child support payments or rely on disability or retirement income or savings. We also have heard concerns of advertising or statements of saying no Section 8 vouchers or something similar to that, or employment only. And then also, rejecting applicants because of their specific form of sources of income. And then also, it could look like rejecting applicants that are unemployed, of saying that this person can't show a work history, but of course, they might also be able to pay their rent through, other forms of income and benefits. And so these kind of categorical statements are just like any other protected bases, and those are the ones that we're on the lookout for. So as with in other cases, the key that we're transmitting to housing providers is to be consistent, to treat individuals the same reasonably, and looking to see that if they're requiring specific rent, specific security deposits, they're doing credit checks or background checks, and have documentation that they require, to apply those same standards across the board and not treating people differently based upon their source of income. And when in doubt, that interactive, communication and saying, what is acceptable, having very transparent policies and processes, has been a very big benefit. And even though the law in Illinois is effective just of January, we have already seen a shift culturally in the housing industry of saying, that people want to comply with this. We want to make sure that we're providing this opportunity, which also, in addition to the benefit for individuals, benefits the entire state and entire, local communities, because of the ability for people to live where they would want to live, instead of being concentrated in specific cases that are, more used to specific sources of income. So I will turn it back to Oral for our contact information.
Yes, so as you can see on the screen, my contact information is oral.bennett@illinois.gov, and Stevens is steven@illinois.gov. So feel free to, if you have any questions concerning what we discussed today, feel free to reach out to us, or if you have questions about any other area of the law that the Illinois Department of Human Rights has jurisdiction over, feel free to reach out to us.
And we have a lot of information on our website, dhr.illinois.gov. And so, look forward to interacting with you if you have any questions or best practices. And it's, a pleasure hearing from our colleagues from the region and seeing how, each state is working on very similar issues.
Well, thank you all to all of our panelists for sharing today about their respective states and fair housing practices. We're going to jump into our question and answer session. So if you are in the audience and you think of a question, please place that into the chat. But I'm going to also ask that our other two panelists come back on with their cameras, and we can start with one question that we have for everyone. So since we do have folks from Illinois, Indiana, and Ohio, I would love if you could just briefly mention kind of how does it work, or how does it work in your state to file a discrimination complaint? Because I know it does look different for each of us.
Well, I can start. In the state of Ohio, to file a discrimination complaint, and because it's housing, I can limit it to housing. Basically mirrors a federal statute. You have a year from the alleged date of harm to file a charge, unless you are challenging a policy or practice which is systemic and it would be ongoing. Once you file a charge with the Ohio Civil Rights Commission, the first thing we do is offer mediation. Generally, if it's a systemic case, we don't like to offer mediation. Although mediation may create a win-win situation for the two of them, we are always looking out for the public interest. And some things you just don't need to take a few $1,000s and walk away from. And we have an ending statute here, which means we must issue a complaint within a year. So that kind of tightened the belt for us. So you have a year to file in housing, but we have to get that case out if we're going to find any cause within a year. And after that, if we can't get it conciliated, and we have a unique reconsideration process where you can come before the commission and argue your case. if it's still upheld as probable cause, we do send it over to the state of Ohio Ohio Attorney General's office for to dispose of. It could be litigation in court. It could be before our administrative law judge. So that's Ohio.
Okay, I can go next. In Indiana, there's several ways an individual can file a complaint. They can first contact our office, 317-233-2600. They can also file a complaint online through our website, icrc.in.gov. Or they can actually come into our office to file a complaint. Basically, they are interviewed by one of our intake specialists to determine whether we actually have jurisdiction over that complaint. The complaint is drafted. If it's determined we do, their signature is captured, and then the case is input, of course, into our systems and given to our prospective investigative units for investigation. Once they've investigated the complaint, it's given to the supervisor for review and to make sure everything has been gathered and so forth. And then it's given to the executive director or deputy director for signature of the actual notice of finding, which determines what we found during our investigation.
I would just like to circle back real quick to say, similar to Melissa, when you talk about filing a charge with the Ohio Civil Rights Commission, you can file the same way via online at our website, or we're actually meeting in person. We had stopped that during COVID, but recently we started having the public come back in and you can file your charge in person. You can mail a charge in. We'll take it over the phone. So we have many ways to get the charge filed in our office. And we always check for jurisdiction.
Yes, we have the same process, many ways of filing a housing complaint in Illinois. Of course, that's our complaints or our inquiries, different terminology. Those are, the first step in the process, and then our intake investigators, transform that into a charge that is a kind of a more, detailed document that then it's going to be investigated. So in addition to the processes, we also, encourage people to have the basic information of what happened to them, who was it, the who, what, when, where, and the why, very importantly, so that we can assess it and say, what is the connection to the protected class or the protected bases, and what happened to, the individual. And that is sometimes the hardest challenge of individuals coming to us and being able to determine, okay, why did this occur and how do we fit this into the law?
Well, thank you all. I also want to ask about kind of another type of thing that we can do, which is educating and spreading awareness to the public, and specifically landlords and property managers. How can we work to educate them on fair housing, especially around those topics of appraisal discrimination, source of income, arrest record discrimination? What can we do to ensure that we're educating, those people that need to know in the best way possible?
Okay, I'll go again. Well, you know what? The first thing we need to do is to invite them to sessions like this, where we're giving out information. We do have to get out there, and if you have to literally, I'm saying hit the streets, but what I mean is we have to go to the people and educate them on the laws here, different seminars or fair housing conferences, and we have to do it if possible advertisement, and we have to work with all these community groups and grassroots groups, and it's just a matter of getting the word out. So I push education.
I agree with Darlene. That piece is very important for getting the information out there. I think we oftentimes go to those communities where we see the most complaints, but I think we should also reach out to those communities where we don't, because those individuals may not know we even exist or may not even know that they're being discriminated against. So, reach out to some of those areas that don't have human rights agencies, or, just are in the middle of nowhere and don't really have the means to get the information.
Yeah, absolutely. And in Illinois, we're being very focused on what is the form of the information. So, trying to give both long technical guides and legal non-binding opinions and guidance, but also very easy to read pamphlets and having information for different audiences. And then especially with housing providers, trying to kind of make it a permanent part of the conversation where fair housing isn't just something that is extra, but is integrated at all parts, from the design to the actual, interacting with a person if they're giving specific requests. So really showing that this is something that is, throughout every housing interaction should have a fair housing lens.
Oh, Oral, you're muted.
Sorry about that. Just to add to that, the use of social media, there's LinkedIn, Facebook, Twitter, Instagram, all those different forums. If you have guidance, if you have trainings, if you have, anything that can shed some light on fair housing, should upload it to those different sources so that people who log into those sources will see that information and make use of it.
I think I want time for maybe one more question. And so just to educate the folks that are here who may be unfamiliar, there are 7 protected classes under the Federal Fair Housing Law. And outside of the Federal Fair Housing Act, what if you could go around and share if there are any protected classes within your state civil rights law outside of those 7?
Well, I can tell you in Ohio, we have military status, and I know that's not federal. I think I forgot to mention earlier that we do cover familial status, similar to the fair housing laws, but military status is the one that I'm aware of. And interesting enough, we are pretty specific about insurance redlining and appraisal discrimination and deeply in our statute. We don't have source of income. So I know that much.
I'll go next. So in Illinois, we have age, ancestry, pregnancy, marital status, military status, unfavorable discharge for military service, order of protection status, and the 2 that we covered here today, source of income and arrest record. Uh, in addition to that, our state actually has actual and perceived. So it's actual or perceived age, ancestry, pregnancy, etc. So pretty broad jurisdiction over the different protected categories.
Yes, in Indiana, we also have the veteran status and ancestry. It's not covered in housing, of course, but as far as our other protections under the civil rights law, those are 2 that are in addition to the 7.
Well, thank you, everyone. I don't think we really have much time for any more questions. I want to share a little bit of information with all of our attendees before we leave. So thank you to the Ohio Civil Rights Commission. Thank you to the Illinois Department of Human Rights. And thank you, of course, to our team here at the Indiana Civil Rights Commission. If you'd like to get in touch with any of our panelists, I know some of them shared their contact information. I'll put it back on the screen for everyone. This is everyone's email, so if you'd like to jot those down and get into contact with them, we encourage you all to connect and share resources about fair housing. So before everyone leaves today, I have a few last little reminders. Just a reminder, we have another panel on Monday, April 24th at 2 p.m. Eastern Time, and we'll have 3 new panelists joining us. So we hope that you all can join us, and I believe Brooklyn's dropping the link in the chat, so if you haven't registered, please do so. You do have to register for each panel separately. We'd also like to mention that the Indiana Civil Rights Commission is hosting a conference. The 2023 Indiana Civil Rights Commission Annual Conference will be held from June 19th through June 21st in downtown Indianapolis at the Crown Plaza in downtown Union Station. The Civil Rights Commission, in partnership with the Indiana Governor's Council for People with Disabilities, will host this conference in person and virtually through an interactive hybrid experience to foster accessibility and inclusion for all participants. To learn more, scan the QR code on your screen or go to the link that has just been dropped in the chat. We hope that we will see you all at this year's conference. And finally, I have one more. So that we can hear from you all, we would love to hear your feedback on today's panel. You can access the survey again through scanning the QR code on your screen or following the link that our team has just dropped in the chat. Please it should take no more than 2 minutes to complete the survey and let us know what you thought. So thank you all for attending, and it's exactly 3 p.m. So we ended on time, and I just want to say thank you to our team again here at the Civil Rights Commission for helping put this presentation on. Thank you to our panelists. Have a wonderful day.
Thank you for the invitation. Bye.
Thank you.